intense effort and work that's gone into the heads, references to various aspects of the evidence, make it much easier for us to handle a 40,000-page record than I feared would be the case at the beginning. And while I'm about it, I also want to say how grateful we are to the three parties, quasi-parties, who led expert evidence. That's the police who gave us the evidence, Mr. DeRover, the Human Rights Commissioner gave us the evidence, Mr. White, and the Legal Resources Centre gave us the evidence of Mr. Hendricks. There's a substantial measure of agreement between them. Points on which they differ, obviously matters we'd have to carefully consider, but we feel more confident than we otherwise would have been by the fact that we have the benefit of expert evidence from these witnesses, which makes a big difference in a commission of this kind. Ms. LaRue, would you like now to continue with your argument?
Yes, thank you, Chair, and thank you for that expression of appreciation. Chair, if I could start by just addressing an issue that arose yesterday in the evidence leader's address, where my learned friend Mr. Chaskelson, referencing the alleged attack on Papa 11, and Chair, this is dealt with in the evidence leader's heads, page 39, paragraph 731.9, where the submission is made that there is clear evidence of attacks before the shooting on the before the shootings on the SAPS vehicles to the east of the kraal, and that this is evidence which has to be accepted even if you discount the SAPS version of events relating to incidents 1 and 2. And Chair, the footnote reference there, it's footnote 1146, refers to the supplementary statements of Warrant Officer Mamabolo, which is triple K 60, and Sergeant Matava, which is triple M 29. Now, Chair, this is a submission that the Human Rights Commission strongly disagrees with and would like to draw your attention to our submissions, page 99, paragraph A, where these self-same members, Warrant Officer Mamabolo and Sergeant Matava, the statements that are relied on by the evidence leaders for their submissions are these officers' supplementary statements. Their initial statements, we submit, constitute dishonest evidence because they claimed that they were, so Constable Mamabolo alleged that he had seen members led by Major General Naidu climbing over the rocks at scene 2, firing at protesters. He called ceasefire because he could see no threat, but his calls were ignored. Constable Matava alleged that he witnessed Major General Naidu firing his pistol at a protester from the rocks. Yet neither of their initial statements contained this highly relevant evidence, and their initial statements originally had absolutely no evidence about scene 2 and falsely claimed that Papa 11 had parked 150 meters away from Kopi 3. So given that glaring inconsistency between the two statements, we would submit that accepting the supplementary statement as clear evidence would be an error by the Commission. But in any event, at its highest, the content of the supplementary statements indicates evidence of an attack on property, the tires of the Inyala. It's certainly not an attack on life, the members within that Inyala. And therefore, its significance in terms of being able to justify any conduct by the police and their use of force would certainly be minimal. But, Chair, in addition, if you consider video V2, which is quadruple U 10.2, that's the video that follows the movement of the strikers leaving the Kopi and around the kraal. In that footage, which follows them continuously, certainly by the lead group, there is no approach made to Papa 11. There is no attempt to damage the tires or any other evidence of this alleged attack that is evident in that footage. And it does not appear to be a period of time in that video footage where such a thing could have taken place. So for all of those reasons, we would respectfully but strongly disagree with the evidence leaders' characterization of that evidence as clear evidence that could be accepted of attacks preceding the shootings. Chair, having dealt with that, if I now can return to my main address, and it serves well to start with where the Human Rights Commission's participation here, what it's always been founded on, and that is Section 11 of the Constitution, which is the right to life. Together with the right to human dignity as well as freedom and security of the person, this is what has informed the human rights-based approach that we have presented to the Commission. The right to life, of course, is recognized and protected both in domestic law as well as in all of the global human rights instruments that South Africa is a party to, and it's been described as the most fundamental right, without which all others are meaningless. It has two components, both of which are important because they provide some legal context to the Commission's work, and they determine, to some extent, the process by which it fulfills its mandate, as set out in the terms of reference. The first of these is to prevent the arbitrary deprivation of life. And, Chair, related to that is the principle of prevention precaution in these circumstances that I addressed yesterday and will deal with again later. But secondly, a duty arises on the state to investigate and ensure accountability where there has been an arbitrary deprivation of the right to life. And the requirements and nature of that investigation are relevant to the Commission's work. Because, Chair, we submit that this positive obligation on the state is an obligation for it to initiate an investigation that is formal, that is independent, that is expeditious, and that is focused on looking at the justification, if any, for the use of force by the state. This Commission is therefore the chosen instrument to satisfy that duty, and it's the instrument by which an investigation has been conducted to ensure accountability, to combat impunity, and to address the indifference of the South African state and the police service in particular to the taking of life and the violation of the right to life that occurred at Marikana. So, Chair, all of this proceeds from the presumption that the taking of life by the state is unlawful until proven otherwise.
Life by anybody, whether by the state or anybody else, is unlawful unless proven otherwise. That's effectively what cases like Mbasa and Felix decide.
Correct, Chair. And therefore, this also means that there is a burden of proof imposed on the SABC, which we submit it has not discharged before you. Chair, if I can then turn to address the two related issues of the standard of proof in the Commission as well as the burden of proof. And if I start with the standard of proof that would be appropriate here, and Chair, in this regard, we associate ourselves not only with the submissions by my learned friend Mr. Budlander yesterday, but also the extensively referenced and researched submissions made by my learned friends for the LRC in their heads of argument commencing at page 73. And Chair, the starting point when approaching standards of proof in this Commission would be the notion of flexibility, because it is not a court of law. It is not applying slavishly either a criminal or a civil standard. And there is no requirement that the same standard of proof be applied to all questions that are before you. Since it would be appropriate, therefore, to apply different standards of proof for different issues, there are at least three submissions that we make in this regard. The first is that when you are fulfilling your terms of reference and considering whether there are matters that should be referred for prosecution or further investigation, that determination should be made once the standard of a prima facie case is satisfied. This is the same standard used by the National Prosecuting Authority when it entertains the same question, and we see no reason to deviate from that. Secondly, Chair, the standard of proof to be applied to a particular question, we submit, would mean to be determined by the amount of evidence available to you for consideration. Therefore, where the Commission is confident that it's heard most or all of the evidence relating to a particular issue, it may be appropriate to apply a higher standard, such as the balance of probabilities. However, where it is clear that you have only heard part of the evidence, a lower standard of proof would then be appropriate while still discharging your mandate and investigative duty. And, Chair, that lower standard of proof has been described by the evidence leaders as reasonable suspicion. To put it slightly more neutrally, if you reached a reasonable conclusion on a particular issue, that would be appropriate. Chair, the example we gave you in the heads of argument relate to the allegations made by Officers Myburg and Swartz, which we would submit are an example of where you have not heard complete evidence in relation to which version to choose between, but there certainly seems to be an issue worthy of further investigation there. And on that reasonable conclusion or reasonable suspicion that these allegations would benefit from further scrutiny, they should be referred to the appropriate authorities and institutions. And, Chair, thirdly, it would be appropriate to apply a lower standard of proof where there have been practical hurdles to obtaining this complete evidence on a particular issue. Now, those practical hurdles may simply be the hearing procedures of the Commission have not enabled us to hear from absolutely everybody who may have had relevant or material evidence to provide you in oral testimony. However, it could also be because a party before you has not provided, either through refusal or some other failure, to provide you with all of the relevant evidence in its possession and control. Chair, where parties before you have not engaged in a full and open manner, we would submit a lower standard of proof could be applied in reaching findings adverse to that party. This is another way of saying that adverse inferences can be drawn against a party, where it was within its power to provide you with the evidence and information necessary to determine a question on a higher standard. It has refused or failed to do so. Therefore, a lower standard of proof is appropriate. Chair, an obvious example there would be the appalling inadequacy of many of the police statements that are before you. Chair, in our heads, we have made these submissions relating to the standard of proof applicable here, and we also used an analogy to the standard of proof that's applicable in inquest proceedings. We made that analogy because an inquest serves a strikingly similar purpose to this Commission. It promotes public confidence and is responsible to account. Section 16(2)(d) of the Inquests Act provides that whether a death was brought about by any act or omission prima facie involving or amounting to an offence on the part of any person is the standard that it applies. We referenced the case of the Matthews-Ganiwe inquest in our heads at page 880, where the judge held that the question is simply whether there is evidence available which, at a subsequent criminal trial, may be held to be credible and acceptable, and, if accepted, can prove that the death was brought about by an act or omission involving or amounting to the commission of a criminal offence by person or persons. So, Chair, to round off our submissions relating to the standard of proof, it's simply to state that it is not for this Commission to make a final determination of these type of issues and rights for all purposes, for all questions, in order to satisfy its terms of reference. It may be appropriate that it discharges its investigative duty and satisfies the quest for accountability here, but applies a lower standard of proof to certain questions where there are deficiencies in the evidence before you. Chair, if I then turn to the related question of the burdens of proof, we've all heard repeatedly that the SABC case before you is one of self or private defence. It has two elements that need to be satisfied: the principle of necessity, where every shooter would have to establish a genuine and reasonable belief of an imminent threat to life, and that a determination was made that lethal force was absolutely necessary in the circumstances. And secondly, the SABC would need to satisfy the principle of proportionality, which requires that lethal force used was the minimum reasonably necessary in the circumstances to neutralize the perceived threat. Chair, it means that the SABC bears the burden of proving here bear the burden of proving justification for its use of force at Marikana, in both respects, necessity and proportionality. For all the reasons set out in our heads of argument, we submit... I
didn't understand that from the day the case opened, the day we started sitting, and the opening speech was made, I didn't understand Mr. Semenya to contend anything different. He said, this is out of case. We say that deaths were caused by private defence or self-defence, and we will establish that. That was his attitude. So,
But, Chair, it does mean that it is therefore open to the Commission, because we submit that the SABC have failed to discharge that accepted burden in either respect. It is open to the Commission to find that that failure to discharge the burden establishes a prima facie case that the killings and the use of force were unlawful by the SABC. Either or both, because they've...
Doesn't that follow from the principle that sometimes the terminology is not entirely clear or consistent, But where a party bears an onus in the true sense, that party also bears the risk of non-persuasion. In other words, if it's not clear at the end of the day whether the killings were justified, then I know your argument is that it is clear they weren't, but I'm dealing with the next logical stage in the matter. If the Commission is not persuaded, then the risk of non-persuasion lies with the police. Therefore, that leads to a finding against them. That seems to be trite law, I would have imagined. The terminology isn't always clear. And some people say that there's no onus in a commission. Well, that's not entirely true. Because if there's a situation that is not clear, and some party must, in the circumstances, bear the risk of non-persuasion, consequences flow from that. But anyway, I'm sorry to interrupt you, but that seems to be the way the proposition should be stated accurately so it can be better understood.
Yes, Chair, and of course, where the party has not discharged that burden, the finding would not only be that there is evidence of unlawful killing, but that would then provide a basis for the Commission when it applies its mind to whether there are further prosecutions or further investigations that should flow. We would submit that would satisfy the prima facie standard of proof that would then be applicable. Chair, I'm relieved to hear you state that the SAPs have accepted that as their burden, because in their heads of argument...
Well, I'm saying they did at the beginning, as I understood it.
Yes, Chair.
And I would have thought that in the light of a case like Mabaso and Felix, they were right to adopt that attitude.
But, Chair, it remains that in paragraphs 96 to 99 of the SAP's heads of argument, dealt with in reply by the Human Rights Commission at page 12 from paragraph 23 onwards in our replying submissions, the SAPS submits there that no adverse inference can be drawn from the fact that SAPS have not called every SAPS member who fired a shot as a witness to give oral evidence, and that this seems to somehow amount to a reliance on the Commission's ruling that the SAPS bears no responsibility to justify the proportionality of every shot fired.
I must confess, I don't understand the problem that you have with that submission of the police. If the police had said, we've been challenged now to call every person who fired a shot, every shooter. I'm not quite sure, I presume some clever person has done the sums, but I'm not quite sure how many shooters there were, but there were lots and lots and lots of shooters. And I don't know whether we would have beaten Lord Savile's record, but certainly we would have sat here for a very, very long time, hearing every shooter coming and being cross-examined from every angle by all the parties who come here, have asked all sorts of interesting, relevant, and uninteresting and irrelevant questions. So I don't criticize the police for not calling everyone. If they wanted to call everyone, I don't know whether my medical advisors would have been satisfied with a decision of theirs to do that. And I wouldn't be the only person in that category. And I indicated in the ruling I gave that I didn't expect them to call everyone. I gave them the assurance, and I'm quite satisfied, was entirely justified in doing so, that no inference would be drawn against them because they didn't propose doing what would have been totally unreasonable and, in fact, impossible regard being had at the time in which we were operating. The statements are before us, of course, of most of the people. The fact that particularly important people may not have been called is obviously in a different category. But the mere fact that how many people were there who fired shots, Mrs. Menia? 300, 400? What's the number?
It is 160 odd.
160. Well, how many witnesses do we have? About 59, wasn't it?
Indeed, Chair.
59. So, and how many of the shooters came and gave evidence? No. How many?
And 0 at scene 1.
I thought you were addressing me, Chair.
All right, well, sorry, what did you say, Mr. Semenya? I didn't hear that. Share the joke with me.
No, I thought you were addressing me. Now I'm hearing zeros and numbers and whatever else coming from there.
Well, your learned friends are trying to help you. Anyway, the point of the matter was that we couldn't have had all the shooters, We had a lot of evidence about shooting. General Naidu, for example, was a shooter who came and gave evidence, for example, and there were some others. But the fact of the matter is that you can't, in my opinion, and I'm indicating that clearly now, so if you want to try to persuade me I'm wrong, you must do so. You can't say because the police didn't call every shooter, you must draw an inference against them, because you're expecting the police to behave in a way which would be totally subversive of the expeditious. You know, one of the things you said was a tribunal of this kind, if it's tribunal is the right word, investigating body of this kind, should do various things. And one of them was proceed with expedition. Well, we tried to proceed with expedition. Some people may say that the sitting for 2 years showed that we didn't comply with that obligation. If we tried to be too expeditious, of course, then we might have avoided making all sorts of discoveries that we actually made along the way. But certainly the result would have been so totally removed from expeditious that I hesitate to think of what adjective would be appropriate.
Yes, Chair, and I must be clear about where we have a disagreement with the SABC that is addressed in our reply. We certainly do not challenge the Commission's ruling. We understand, however, from the heads of argument of the SABC that their interpretation of the ruling is that the failure to provide oral evidence is a basis on which they can be excused from having adverse inferences drawn against them. And in response to that, we say the failure to have oral evidence does not lift your burden of justification. You needed to put up written statements that satisfied and demonstrated both necessity and proportionality, and you failed to provide evidence in any form that would discharge that burden. That's the point of this
argument. I understand that argument. That's another argument altogether. In other words, provided the shooters have given evidence, albeit in writing rather than orally from the witness chair, one must look at what they say, whether they say it in writing or say it orally. I understand that argument. And if one assumes that what's in their written statement is what they would have said in the witness chair, and they would have said nothing else, then, of course, one can deal with that evidence on the basis that one would have done if that evidence had been given orally. So there isn't a problem with that, surely.
And that is our only argument. That is the only point, that it relates to whether they've discharged their burden not just because they couldn't bring witnesses to this room, but because they failed to put up any evidence that the Commission could use to find that the use of force had been justified. Chair, I'd like to then move on to address some of the issues that are addressed in Part 4 of our Heads of Argument, which commence at page 60. The first three of those relate to three consequences that we submit must follow from the deficiencies of the SABC evidence before you, as well as its general approach to the Commission. And Chair, first and fundamentally to these consequences is the SABC's failure to engage in a spirit of full and frank disclosure with the Commission. We would submit that the SABC's case before this Commission has been characterized by a culture of denial and impunity, and a failure to engage in a spirit of full and frank disclosure. We've submitted in the heads the details of what we submit is deliberate misleading of the Commission on a number of key issues, as well as the concealment of vital evidence. Moreover...
I don't want to stop you. A good deal of the material covered in this part of your heads has already been dealt with by Mr. Shaskerson.
Yes, Chair, and I don't intend to repeat
that. So you don't have to traverse it again. Those facts are before us.
Yes, Chair.
Whether the inference that the evidence leaders ask us to draw is one that can appropriately be drawn is a matter that presumably will be dealt with later. But the instances of alleged lack of candor and lack of cooperation and concealment and so forth, those are before us.
Yes, Chair.
For what they were.
And what we would submit is that this all ties back to the fundamental submission that the Human Rights Commission makes before you, which is the need to hold the SABC accountable as an organization. Because we heard from Mr. Derova, the SABC's own expert, as to the resistance and obstacles that he encountered to disclosure, to reflection, and to any redress. His pithy phrase was that lessons learned were considered as mistakes made. And we know from the statements made at the time by the SABC leadership that a very clear message was sent that no mistakes were made, that there was nothing that could have been done differently, that there was nothing to account for. And we submitted that those were premature, irresponsible, and wrong. Because, Chair, it's one thing for the leadership of the SAPS to have been concerned for the morale of an organization in the aftermath of a tragic event. But it's quite another to publicly exonerate the entire organization, unequivocally, without first conducting even a cursory investigation. Chair, the SAPS also, and you have all of the evidence and all the references, but it also committed itself to its self and private defense case without any real knowledge of what had happened at Scene 1 or Scene 2. No investigation, no debriefing. This set the tone for the participation in this commission process, which, to use the phrase of one of the reports that we refer to in our heads of argument, this is the proverbial blue wall of silence that the police erect in the aftermath of an event where they would need to be held accountable. And there are many bricks in that wall. Mr. Chaskelson covered several of these, but it's the failure to debrief. The meeting at Roots, which not only produced a discredited Exhibit L, but seemed to mold the SAPS case into one that was designed to be consistent and faithful to a self and private defense case, with no recognition of wrongdoing. At Roots, none of the measures were taken that may have shielded the SAPS against these claims of collusion. Those are set out in our heads at page 74. And ultimately, documents that were presented to the Commission as contemporaneous were in fact drafted at Roots. We then had the fortuitous disclosure of the Scott hard drive with its treasure trove of contemporaneous documents and the documents that show up this creation of evidence later at Roots. Then we have all of the discredited...
It wasn't entirely fortuitous. It was a result of pressure, which was a combination of a long, obviously many, many hours of hard work. So fortuitous is the wrong word, I think.
And Chair, it culminates with the key false claims in the police case, which are summarized in a table on page 82 of our heads of argument. These are set out in more detail commencing from page 76. But Chair, if I can briefly go through those 5 key false claims. The first is the claim that the plan had been devised and approved on the 14th of August as part of a comprehensive planning process with input from various commanders, and that the decision to implement Stage 3 was taken on the 16th of August in response to an escalation of the threat by the strikers. We know that's false. We know there was no plan. We know it was devised under significant time pressure with no input from POP commanders, that the decision to implement that was taken at the NMF without any reference to the operational leadership at Marikana. The second key false claim is that prior to the SAPS firing live ammunition at Scene 1, the SAPS had defended themselves against 2 previous attacks, that they had used less lethal methods, including water cannon, tear gas, and stun grenade. Chair, we now know there were no previous attacks by the strikers on the police lines, and the SAPS in their heads of argument and reply seem to accept that there is no Incident 1 and no Incident 2. Similarly, the less than lethal measures were not used against the lead group, and those that were used against them were used in a way that inappropriately and ineffectively drove them towards the TRT line. The third false claim is that the SAPS fired live ammunition for only 8 seconds and then stopped in response to a call for ceasefire, when in fact we know that the volley lasted for 12 seconds, with intermittent shots from R5 rifles and potentially sidearms continuing for more than a minute, and that the calls for ceasefire commenced within 4 seconds and are ignored. Fourthly, we know that the claim that the JOC members and the operational command were unaware of the shooting, they were unaware of the deaths or the serious injuries at Scene 1 or Scene 2 until approximately 20 past 4, where now we know that in fact the JOC was aware of the use of live ammunition at Scene 1, aware of the high probability of deaths and injuries, and was aware of this before Scene 2 had commenced. And finally, there was the false claim that Scene 2 occurred as various units approached Corpi 3 in order to carry out the disperse, disarm, and arrest plan and responded with live ammunition to life-threatening attacks by the strikers, when in fact, and as acknowledged by certain of the SAPS witnesses, Scene 2 occurred because of a complete breakdown in commanded control and the creation of a situation of dangerous crossfire. In addition, the SAPS witnesses have provided you with evidence of at least one unlawful execution-style killing of a striker. There is no adequate explanation for at least 14 deaths, and it appears that most likely those 14 deaths were caused by recklessly fired and stray bullets. So, Chair, in sum, and in addition, the SAPs failed to comply with explicit discovery obligations. These are set out in the annexures to our heads of argument as well as canvassed at page 85, section 1.5 of our heads. Discovery obligations were met with various inadequate responses. One would be, there are no such documents. We would then discover belatedly there are in fact such documents. We were told that requests were made and nothing responsive was produced. Witnesses then came and testified that they were never asked. So the deficiencies and the failure to comply with discovery obligations similarly has contributed to the lack of evidence before you by the SAPs. And finally, there's the failure to provide adequate statements or statements at all. Chair, the inadequacy of the statements is canvassed at page 91, section 1.6 of our heads, and the failure to provide statements for several members at all who were at Marikana and may have assisted the Commission is addressed at page 100, section 1.7. But what I need to say about the provision of statements by the SAPs is two further things. The first is that the SAPs seem to drip feed this Commission. So statements dribbled in over the 2 years of this inquiry. Deadlines were missed, new deadlines were set, those were missed, third deadlines were set, those were missed. Assurances were given that statements were in production, never produced. But Chair, secondly, it seemed that the drip feed was in response to damaging facts emerging in the Commission. So it was an exercise in damage control, not to come forward fully and frankly to disclose everything that any SAPS member knew that could have been of assistance to you. Indeed, the way Mr. Derova was treated is a manifestation of the same blue wall of silence. Despite being assured that he would have unfettered access, he was never told the full story either. So, Chair, not only has there been a deliberate concealment of evidence, but there has been a knowing presentation of a false case. And we submit that there are 7 evidential consequences that follow and that inform the findings that are possible by the Commission. These are set out in Part 2 of our heads, as well as addressed by my learned friends for the Legal Resources Centre. But, Chair, these 7 consequences are the following. Firstly, the SAPs or any person, any party before the Commission should not be permitted to benefit from its own failure or refusal to provide adequate evidence to the Commission. Secondly, the Commission can have no confidence that it has all relevant documentary material in the possession of the SAPs. Thirdly, it can have no confidence that the SAPS witnesses have disclosed all relevant information within their knowledge to the Commission during their testimony. Fourthly, as a result, where the only evidence available to the Commission is that of a SAPS witness, and there are prima facie reasons to doubt that evidence, it should be treated by the Commission with the utmost caution. Where there is SAPS witness evidence that is contradicted by contemporaneous material, whether it's video, photo, or documentary, we would submit that that material needs to be preferred over anything that was testified to. Where there is no evidence provided by the SAPS on matters that ought to have been within its members' knowledge, we submit that adverse inferences can and should be drawn as to why that evidence wasn't provided and what it may have shown. And finally, where it's impossible to reach a finding on a balance of probabilities because of these deficiencies and failures in the provision of evidence by the SAPs, we would submit that a lower standard of proof is appropriate and it would be acceptable for the Commission to reach conclusions based on a reasonable suspicion or a reasonable conclusion standard. So, Chair, those are the consequences of the SAPS's failure to engage in a full and frank manner with the Commission. The second consequence of its approach in the Commission relates to the failure to retain contemporaneous records for decision-making and planning and your findings in relation to those. These are addressed in Part 4, Section 2, page 120 of our heads. And essentially, Chair, I won't go through the evidence again, but we know there's an admitted failure by the SAPs to maintain adequate record keeping of the decision-making and the planning of the Marikana operation. As a result of that, where we do have contemporaneous documentation, it should be preferred to any evidence by a witness. But even then, we should treat it with some caution because of the fabrication of documentation that we know from the disclosure of the Scott hard drive. So similarly, when the Commission is coming to its findings with respect to decision-making and planning, we would caution the Commission that these principles would probably need to be applied to that when it tries to reach its findings. Thirdly and finally, Chair, there's a further consequence which relates to the inadequacy of the statements for your conclusions about necessity and proportionality on the use of force. Again, the approach is to justify each and every shot, to justify the start and continuation of shooting. Very practically, what this means is we need to understand the justification for firing bullet 1 in second 1. We need to understand the justification for firing at second 12 or second 60. We need to understand the justification for firing bullet number 25 by an individual member. All of this, both singly and cumulatively, would need to be put before you in order for the SABC to have discharged its burden to justify the use of force. And Chair, in this regard, I must pause to note our submissions relating to a matter that received some attention during the course of the Commission proceedings, namely the status of warning statements. Chair, we submit that it's entirely irrelevant because the point is that this Commission does not have adequate evidence to find that the SABC justified the use of force. The fact that some of that evidence before you is in the format of a warning statement is not the point. The point is the failure by the SABC to provide all information. Of course, there is a point to be made about warning statements, which is where an officer has decided to waive his right to self-incrimination. He must do more than just admit to a prima facie case of unlawful killing. He must provide sufficient and extensive detail that would be able to establish the necessity and proportionality of his use of force.
An entirely accurate approach. The warning statement was not, the warning statements were not made for the purpose of the Commission. They were made by the persons who made them in circumstances where they were warned by IPID that they were suspects, they were told of their rights, and they were then invited to make statements. They obviously would have borne in mind that if they are charged criminally, the statements will go before the court, and the court will then have to consider the question of whether they're guilty or not in the light, inter alia, of what they said or didn't say in their statements. And it may well be that the failure to mention things that are important, combined with a mention of things that are not so important, would be a factor which the criminal court would bear in mind in assessing the case against a particular deponent or statement maker. I'm not sure they were made under oath. I think they were put under oath later. But it's a different thing where you have a witness who's asked to make a statement for this commission and told that the statement you make can't be used against you in any subsequent criminal case, unless you commit perjury, in which case you can be charged with perjury. That kind of statement is more susceptible, I would imagine, of the kind of inferences being drawn than the case of a mere warning statement. I'm not saying that a warning statement is irrelevant. I'm not saying you can't take it into account. But clearly, you've got to be practical, you've got to bear in, and you've got to be fair. And you've got to bear in mind the circumstances in which the warning statement is made, what the maker of the statement thinks will happen to his statement, compared with a statement made for the purpose of this commission, where that section of the regulation applies, that the statement can't be used against him at all in any subsequent criminal case. That's a distinction that one cannot ignore unless one wants to be unfair. And I hope that by this time it's clear that that's the last thing we want to be in this commission.
Yes,
We've been accused of the opposite by people in circumstances which I suppose we must forgive in this regard being had to the broad picture. but unfairness rather, is not our business.
Chair, let me then bring it down to two submissions. Chair, the point on warning statements is essentially two submissions. The first is where the right to self-incrimination has been waived and some account was given. The Commission can scrutinize that account for its failure to reveal the detail necessary to establish self or private defense. But in addition, and more importantly, the SABC has had 2 years to supplement those statements with statements for this Commission, having explained to its members that they will not be admissible in subsequent criminal proceedings.
That's a different question. Yes. I thought I'd indicated to you already. I can understand that submission. You put up a statement, it's a warning statement, made in circumstances where the statement maker thinks that all that's going to happen to this statement is going to be put before criminal trial if I'm ever charged. That's all. But we are dealing with a different situation where a statement is being made which is designed only for criminal cases. That person is now expected, or the police are now expected, to give a full explanation of what happened, and all they put before us is this statement made in other circumstances with other considerations in mind, and if there are gaps, then those are gaps that may well be important regarding being had to the particular circumstance. Whether they're important in assessing the case against the particular policeman who may or may not have been approached to and asked whether he wishes to supplement his statement, or whether simply they can be used broadly, as it were, against SABC as a body, is of course another question that we'd also have to consider. But I think I've endeavoured to indicate to you what I understand your submission to be, and if I've indicated it correctly, well then fine. If I've indicated a misunderstanding, then I'm afraid you must be patient with me and take me a little bit further down the road you want me to go.
No, Chair, I think we're entirely on the same page in terms of the two submissions, that the nature of the warning statement and the failure of the SABC to supplement. But of course they are related, because to discharge your terms of reference, you need to scrutinize, and the relevant ruling of the Commission relating to the evidence of the shooters states that each and every statement of each and every shooter will be scrutinized in this way. So the failure by the SABC to provide you either with a supplemental statement or some other way in which they could have cured the deficiencies in the warning statements leaves you with only evidence from these individual shooters that seems to reveal unlawful killing and no defense. That's why it does have a consequence in terms of your findings and the potential referral for prosecution or further investigation. That what is before you may be a basis for that referral, and it's the consequence of the warning statements deficiencies themselves to reveal a defense, but in addition, the failure to supplement.
Do you say that the guidelines that have been laid down in many decisions about the approach to the contents of warning statements, that we shouldn't be mindful of those cautions and apply another standard to them?
No, Commissioner Hemraj. Our submission is merely, at the moment, with respect to the overwhelming majority of shooters, the evidence you have is warning statements. The explanation for the deficiencies of those warning statements and their failure to reveal a defense may be the result of there being warning statements. But then, for your purposes, there was a burden on the SABC to supplement that evidence and provide you with the detail that would have revealed self or private defense by those individual shooters. Otherwise, when you, as the Commission, evaluate those statements, trying to determine whether you need to refer people for further investigation or prosecution, all you have is a body of statements that reveal unlawful killing and no defense. Certainly, we accept their status as a warning statement, but once it's being scrutinized through your eyes, discharging your mandate, it has these consequences for those individual officers and the SABC as a whole.
There's a further problem that you haven't touched on, and that is, this point is made clearly in the evidence leader's submissions. In relation to killings, there are two kinds of cases that can follow. One would be a civil case and one would be a criminal case. The criminal case, the onus is on the state to prove beyond reasonable doubt. In the civil case, the onus is on the defendant to establish, on the balance of probabilities, that the killing was justified and proportional and so forth. Now, if we are considering the case from the point of view of referring the matter of a particular shooter to the prosecution authorities, it's with a view to a prosecution being instituted. So that's also got to be factored in. But when one is considering the matter as to whether the police itself is liable for a killing, and even an individual policeman is, as it were, civilly liable ex delicto for a killing, that of course is a different matter. I understand your argument fully in relation to the civil level, the civil liability of the police, civil liability even of a particular shooter. But argument seems to be prima facie, if you forgive my saying it, to involve some kind of oversimplification when one deals with the question of potential criminal liability, which would be the subject of a referral. But of course, the standard doesn't have to be very high for that, because as you say, all one needs is a prima facie case. One assumes that the DPP would have extra investigation done. IPID would resume their investigation where they stopped about 2 years ago and investigate further, and the decision would ultimately be taken on all the information which is available. But it's not quite as simple on the criminal level, I would suggest, as you put it, but I think we understand each other. Am I correct?
Chair, my instructions in this regard are obviously that the Human Rights Commission is very conscious to respect the mandate both of this commission as well as of the NDP and IPID when determining the potential range of offences and the potential individuals that should be referred to those institutions for prosecution. So beyond the submissions that I can make on the applicable standard of proof with respect to a prima facie case, unfortunately I'm unable to assist the Commission any further with respect to identifying.
You made a valiant attempt to assist us, and we're grateful for your efforts.
Chair, if I can then move on to the topic covered in Part 4, Section 6, commencing at page 171 of our heads of argument. This is the approach to expert evidence that was placed before the Commission by three parties and the transformation of Mr. De Rova. Chair, I hope it will be accepted as fairly uncontroversial that expert evidence is required for the Commission to satisfy paragraph 1.2 of the Terms of Reference, that policing, public order policing, and public order policing of violent protest are areas of expertise that we mere lawyers...
Did I not say that in my introductory remarks this morning?
Yes, Chair.
Are you trying to persuade me that what I said was not correct?
No, Chair, I'm just repeating it.
Do you think I need repetition, or do you think I've forgotten what I said? These concurring judgments that the leader of the Johannesburg Bar used to specialize in before he was elevated to higher status.
Chair, if I start with the expert of the Human Rights Commission, Mr. Gary White, we would submit that he is qualified, credible, that his evidence was well referenced, and he demonstrated that he was fully informed with respect to the relevant and material evidence on which his opinions were formed. These are canvassed in detail in the heads, and I do not intend to repeat those. But, Chair, what is critically important is that all three experts that appeared before this commission are in agreement, or broadly speaking, agree with the overwhelming majority of Mr. White's criticisms of the SAP's operation. So, in light of that consensus, there is no reason for the Commission to reject any part of his analysis and criticisms of the operation.
It's not as simple as that either. There's no reason to reject anything he says which the others, you would say, which the others agree with. Clearly, if they don't agree on a particular topic, then one doesn't accept what he says without more because he said it. One has to analyze what he says and what the contrary view is and try to come to a conclusion as to what's correct.
Yes, Chair.
Expert evidence, after all, is the giving of stating of opinions and the giving of reasons, therefore, which are such as to satisfy the court or the commission that the opinions stated by the expert are correct. A mere say-so of an expert takes the case no further.
Yes, of course, Chair. But this consensus between the three experts therefore underpins their recommendations, which similarly are strikingly echo and mirror each other. And Chair, there are the two key opinions expressed by Mr. White that we submit should underpin the Commission's findings. And these underpin his detailed criticisms with respect to the operational failure arising because of poor intelligence planning, briefing, and command and control. And it's the two critical questions that he came back to again and again during his evidence. Why was the plan implemented then? And why was this the plan? So, Chair, what this also means is that his recommendations, which I'll address at the end, are practical measures that he has proposed to combat not only some of the operational deficiencies that he observed, but also to promote accountability within the SABC. These practical steps would, he hopes, change the SABC's culture of impunity and indifference to one of accountability. If we turn then to the evidence of Mr. Derova, what is striking in the submissions by the SABC is that they studiously and conspicuously ignore that the fatal blows to their case were administered by their own expert. There is a disavowal, if they're attempting to disavow his agreements with Mr. White and Mr. Hendricks, that simply doesn't help the SABC before the Commission, because Mr. Derova's demolition of the SABC is not a mere inconvenience that they can step over and continue as before. Because what you have before you is evidence from a qualified policing expert. And if we just highlight three particular elements that should concern the Commission and attract its attention. The first was his conclusion that there was what he called associative threat perception at scene one. That's officers firing because others are firing, not because they observe a threat. Silence from the SABC on that conclusion. He identified 9 victims at scene 2 that he says were killed by what he called incidental fire. Silence from the SABC on that opinion. And finally, his time with us was spent in large part describing the organizational obstructionism that he encountered. Silence from the SABC on how they treated their expert. And we now note from his recommendations provided to you that he appears to now be independent from the SABC and no longer a consultant to them. So, Chair, once we accept Mr. Derova's qualifications and his agreement with Mr. White, we then turn to his independent recommendations, which mirror those of Mr. White. And we would therefore suggest that they are a further reason why that raft of recommendations proposed by the 3 experts should be carefully considered and adopted by the Commission. Chair, finally, if I could deal with the question of the approach to the video evidence that was produced by CALS in collaboration with SERI for the families. This is set out in detail at Part 4, Section 7, commencing at page 201 of our heads of argument. And, Chair, to quote the evidence leaders, they described this as one of the most important pieces of real evidence before this Commission. And, Chair, what struck us in the SABC's heads of argument, particularly page 69 and onwards, is that there seems to now be some agreement from the SABC in relation to what the videos show in certain critical respects. So, for example, not only do they rely on the videos, but they seem to accept that there is no incident 1, page 70, paragraph 165 of their heads, no incident 2, as it was described in Exhibit L, paragraph 166 of their heads, and then paragraph 170 onwards, they accept the splitting of the group into what we've called the main group who turn away from the police lines, the kraal edge group that are pushed towards the kraal by the pop, and then the front group of 12 who come around into the TRT fire. And this turning away of the group and splitting of the group seems to now be accepted by the SABC in reliance on the videos. But, Chair, there's one final point to make with respect to the weight, and we would submit significant weight that should be accorded to the video evidence. And it's this: that the SAPs put up what we can only describe as fairly slapdash objections. Bold statements with no referencing or detail that we were able to deal with in any meaningful way. We've attempted to respond point by point in Annexure F to our heads of argument, but it appears that the thrust of the objection of the SAPs to the videos related chiefly to the annotations that appeared on the video. But of course, that's a question of weight. It's not a question of admissibility or anything like that. The Commission will view those videos. It will accord the weight it decides to accord to the descriptive annotations. It is not something that calls for the rejection of the video, because the Commission will verify whether, when the annotation says this is Papa 2, it in fact is. So with respect, and in light of our detailed response to the criticism in Annexure F, and nothing from the SAPs in reply to that, we would submit that the evidence should be accepted and accorded significant weight by the Commission. Chair, I'd like to turn next to the next topic, which is addressed in parts 9 and 11 of the heads of argument in detail, and try to get through this fairly quickly. And Chair, this is where we would apply the principle of prevention and precaution to what we know from the experts and from the factual evidence were the failures in intelligence decision-making, planning, and briefing in the SAPS operation. So drawing together the principle of prevention and precaution with the factual findings extensively detailed in the heads of argument. Just to orientate ourselves again, the principle of prevention and precaution requires those in command of policing operations in which higher levels of force are anticipated as a possibility to plan and command those operations in such a way as to minimize the risk of the need to use lethal force. Where a policing operation such as this resulted in multiple deaths, the question is not simply, was lethal force used in legitimate self or private defense, or was it used with any other justification, but also to ask, was every step taken to avoid a situation in which lethal force could be used during the planning and command of that operation? Chair, if we start with the intelligence failures, these are set out in Part 9, Section 2 of the heads of argument. Again, the critical submission by the Human Rights Commission and by Mr. White is with respect to how the limited intelligence that was obtained was not taken account of in the planning of the operation. It did not seem to feed through to the planning.
Evidence leaders made as well, that
Yes, Chair.
the intelligence people had great problems in gathering information which one could really understand. Nevertheless, they obtained information which was important and was vital to be borne in mind when the plan was drawn up. The evidence leaders' complaint to the end was not so much that the intelligence gathering was defective, that it was the evidence gathered wasn't borne in mind and applied, taken into consideration when the plan was drafted. That of course, is really a different question, isn't it? It's not really a complaint that goes under the heading of evidence gathering. It really goes under the heading of use of information gathered, isn't that so?
Precisely, Chair, and that is Mr. White's point in this regard. So the questioning of the evidence leaders yesterday, we spent a fair amount of time on trying to identify the individuals that may have been responsible for the intelligence not feeding through to that operation. And while the Commission obviously may want to make factual findings in that regard or make findings in that regard, we would submit, based on Mr. White's opinions, that it is the SAPs that failed. It is those processes within the organization that failed. So the failures may well be those of individual officers who were tasked with taking account of intelligence, feeding it back to the relevant people so that they could take it into account in the planning and command of the operation. But it's the SAPS's failure as an organization that we would submit the focus of the criticism should be. Chair, just so that it's helpful when the transcript is reviewed, of course, we're referring to the discussion yesterday where Brigadier Engelbrecht and Major General Mpembe's roles were discussed in detail. Their individual conduct may be relevant and to the Commission's question, but we would submit, and Mr. White's evidence is that it's the failure in the process that is the reason why intelligence failures are relevant to the operation and the principle of prevention and precaution.
I'm not sure that this
relates
expression,
those two.
So I'm sorry to interrupt you. I'm not sure this expression intelligence failures is a fair one in the circumstances, because it implies that Brigadier Engelbrecht, for example, and those working under him failed to do what they should have done, and they could have done what they should have done if they'd done the right thing, which is by no means self-evident, I would have thought. It's a different question as to if one were to say that there's no basis. I'm not saying this is so. I'm just putting up a prima facie point here. That it may well be that the intelligence gatherers did the best they could. It may well be the information they got was all the evidence, A, that they could get, and B, that was needed for the purposes of making further decisions. It may also be that the mistake was to decide to have the tactical option in the afternoon of Thursday the 16th. It shouldn't have happened in the light of the information. The information may well have been of such a nature as to indicate that it was impossible to conduct a tactical operation on Thursday afternoon without an unavoidable amount of bloodshed, which would have meant that the operation shouldn't have taken place then, and that other methods should have been adopted, or alternatively, it should have been carried out later. But I don't think it's fair to talk about evidence failures. It's other expressions may well be appropriate.
Chair, if I could adopt the language that Mr. White uses in his recommendations, it's the failure to have an intelligence-based plan. So, Chair, the detail of that failure to ground the planning and command of the operation in the known intelligence is set out in our heads, page 287, paragraph 2.1.6. Mr. White referred to that on the 11th of August, Brigadier Engelbrecht receives the reports from the intelligence handler that there's going to be attacks that night and forwards the information to Major General Mpembe with the intention of deploying visible policing. Nothing happens. On the 14th of August...
Again, that raises a matter we discussed yesterday also, and that is that it's not clear to me what General Mpembe should have done that he didn't do. He was on leave. The evidence seems to indicate that he passed it on to the acting provincial commissioner, who would have, with the expectation, which I imagine would have been justified, that the necessary would be done with the information. So I'm not sure that General Mpembe can necessarily be criticised, and I'm not sure that Brigadier Engelbrecht can be criticised. He may well
and be cognizant of the intelligence.
Again, that may be an oversimplification. It may well have been fed through. It may have been that those responsible, or the person responsible for drafting the plan, could do nothing about it. If he was told, you have to have a plan that we're going to use at put up at 1:30, never mind what the intelligence says. Even the intelligence may say, we shouldn't go this afternoon, but you've got to go this afternoon. There's got to be a plan. Again, the criticism, as you framed it, may not be justified. It may be that the person who drafted the plan was very well aware of the intelligence. It may well be that's part of the explanation why he sat the whole morning and wasn't able to produce anything in writing. But these are, and can't remember, in fact, what happened, so he says, on that morning, because he spent a morning looking at the wall in desperation. That may be what happened. But so to criticize him for not feeding the intelligence into his plan may, with respect, not be a proper approach and not a fair one.
But Chair, again, the target of the criticism is not individuals, and it's not exclusively cropped to only look at the 16th. If you look at what's set out in paragraph 2.1.6, we have, on the 11th of August, the report that Brigadier Engelbrecht receives forwarded to Major General Mpembe, no response in visible policing as a result. 14th of August, we get the names of some of the strikers that are visible in the video footage from the 13th. Unclear what was done with any of that information. During the entire week of the 9th to the 16th, we have Brigadier Victor interviewing people and with a view to obtaining information to possibly identify witnesses and suspects. None of that seems to have come through to the crime intelligence officers who were part of the planning team. Lieutenant Colonel Scott confirms that his intelligence...
I'm sorry to interrupt you. The trouble with that is, maybe it's something we should have looked at, but it occurs to me as you put the proposition up, it may be that the people whom they identified were among the 50 who stayed on the Corpi the whole time. You remember, most of them used to come in the morning, go home for lunch, come back in the afternoon, go home in the evening. But the evidence is that about 50 of them stayed there the whole time, you remember. Now, if the people who were identified as people to be arrested were among the 50, then one can understand, as I say, we didn't investigate this, but it's an inference that may be drawn as a reasonable possibility. It may be that they said, look, we can't arrest these people until we've done the dispersal, which is going to be done. And of course, if they'd done the early morning operation, which was planned on the 14th, then it may well be that they would have arrested those people. But these are matters which were overtaken by events, and we didn't investigate. Maybe we should have done. But I would be unhappy to found the criticism on consideration of the kinds you put to us in the view of the fact that those aspects weren't investigated. And it's all very well to say you're criticizing SAPS, you're not criticizing individuals. But, you know, SAPS operates through individuals. The SAPS isn't an incorporeal presence of its own that sort of wafts over the field and does things. It operates through the hands and legs and brains of individuals. And the criticism inevitably relates to those individuals. So we must not be unfair to the individuals concerned.
Of course, Chair, but precisely because we hope to prevent a reoccurrence of Marikana by improving the systems and the processes that other individual officers will have to occupy those roles. That's why we're looking at it from the systemic point of view. But, Chair, all I can ask is that I refer you again to what is set out in paragraph 2.1.6, which details the intelligence that was undertaken during that week. TT5 is the full extent of what fed through, and that deficiency is what the target of the criticism is. Chair, the second thematic criticism that Mr. White makes of the operation, utilizing the principle of prevention and precaution as the foundation, related to decision-making. And this is set out in Part 9, Section 3 of our heads.
Is this going to be a fairly long exposition? Because I was proposing to take the first comfort break at about 10:15 after we sat for an hour and a quarter, which is what we normally do. But I delegate to you the power to indicate when we'll take the first adjournment.
Chair, if I could just round out this point, I will try to do it in the 3 minutes that remain. But the key on decision-making is, again, why go then and why go with this plan? And this relates, the nub of this criticism also relates to the submission that we make that the risks of multiple deaths by the SAPS were both foreseeable and foreseen. And you'll recall the 12 pieces of evidence that were put to Mr. Derova. These are set out commencing at page 301 of our heads of argument, paragraph 3.3.1. Those 12 pieces of evidence, Mr. Derova accepted that the order to disarm the strikers, the decision to proceed, carried such high risks that the order itself may have been unlawful. So the decision-making that preceded the move to the tactical phase, in light of these 12 pieces of evidence we would submit, demonstrated that the SAPS foresaw that lethal force was likely to be used, and therefore applying the principle of prevention and precaution should have taken even more steps to ensure that there were ways to minimize or eliminate the risk that force is going to be necessary. Chair, if we just briefly run through what those 12 pieces of evidence were, it was that force had to be used on the Monday, the 13th of August. Secondly, Lieutenant Colonel Scott's anticipation that force was likely to be necessary. Thirdly, that the intelligence that was available had suggested that the strikers were likely to resist and believed that the police would not shoot them. Fourthly, that this mindset of invincibility that was ascribed to the strikers was taken over into the planning in the risk assessment that was made. Fifthly, that there was information suggesting there were firearms within the possession of the strikers. Sixthly, none of the JOCCOM members who came to give evidence to the Commission indicated any serious expectation that the so-called militant group would voluntarily disarm and disperse. The seventh piece of evidence is that the intelligence noted that the mine workers were in possession of dangerous weapons, that they would decline to surrender, and that they were prepared to resist the police and fight if their demands were not met. The eighth piece of evidence is the reports of serious threats made from the 15th through to the 16th towards the SAPs. Ninth, that Major General Mbombo was recorded on the 14th saying that if the strikers didn't surrender, then it's blood. And her oral evidence was that this warning, that she was warned in the morning that it was likely that live ammunition would be used. 10th is that Lieutenant Colonel Scott testified he was mindful that a tactical option would elicit a violence response from strikers and that he didn't want to send SAPS members into a blatant death trap. 11th was that Brigadier van Sail, on the morning of the 16th of August, requested 4 mortuary vans. And finally, that 4,000 extra rounds of R5 ammunition were ordered.
These two factors that you mentioned indicate there was foresight, and I remember putting that in terms to Mr. de Roover, and that was something that he didn't appear to have been aware of until it was put to him. Indicate that 2 senior people anticipated bloodshed, and in fact a serious firefight on the when the plan was carried out. Whether it was Brigadier Carlitz who did it, or who requested the 4,000 rounds, or Lieutenant Colonel Marafi off his own bat, is something that is subject of dispute. And one of the problems we have is that neither of them were separately represented, so that there was in fact a conflict between them on the issue. And it's unfortunate that we don't have someone arguing for Carlitz as to why the finding shouldn't be made against him, and someone arguing for Marafi the finding shouldn't be made against him. But it doesn't matter at the level that you're busy with. A senior official, senior officer, either a brigadier or a lieutenant colonel, obviously thought there was going to be a serious firefight and asked for 4,000 rounds. And Brigadier van Sail clearly thought mortuary vans would be needed, 4 of them, nogal. And hence he asked for them. Of course, they didn't come, and the 4,000 rounds of ammunition were sent back, but that doesn't alter the fact that they were asked for is evidence of foresight, of serious trouble and potential bloodshed. What is the most important one, I would have thought, is the third last one, the anti-penultimate one in your list, because there, you'll remember the Goldstone Commission book on the Regulation of Gatherings Act, or building bill form. So one of the things you've got to do is you've got to consider the things that could happen, and descending order, as it were, of probability, and have a plan in place to deal with each of them. And what this one indicates is that Scott foresaw the possibility that the POP people couldn't handle the matter with less than lethal force, that they would in fact have to flee for their lives into the Inyalas, and the TRT people would have to be in place to deal with that contingency, and the only way they could deal with it was by using their R5s. So that factor in itself is very important at the replanning level as to what was foreseeable and what was done to cater for that foreseeable contingency. But I'm sorry.
And Chair, on that restatement of the principle of prevention and precaution, perhaps we should take the agenda.
Yes, it sounds like a proposition that's difficult to resist. We'll take a 15-minute adjournment.